Welcome to Planning for Success, an overview of legal issues every entrepreneur needs to know. Please welcome your speaker, Michael Leventhal.
Hey everybody, welcome. So how many of you are old enough to have gone to a bunch of demos that utterly failed technically while you were prepared to enjoy something? Okay. Actually, you could probably just be 1 year old and that would happen, but so that's where I am right now. This is my presentation. My new computer just decided that it didn't want to cooperate. So there may be a little bit of this going on, but other than that, we should be good. Okay, so welcome everybody to Planning for Success, an overview of legal issues that every entrepreneur needs to know. So if you are starting up a company or thinking about it or in the early stages, this is the right place for you. Also, if you are tired of all the sexy bells and whistles and lasers, this is a good place to chill for about 45-50 minutes. So I'm Michael Leventhal. I've been a business lawyer for over half my life. I just finished a 5-year stint with Magic Leap, most of that as either a chief legal officer or vice president. I've been in the digital tech, digital media field for 25 years and intellectual property and entertainment for a bit longer. So those are the things that I know. So I'm assuming that most of the people in here are part of a company or planning to be part of a company that's going to do that Silicon Valley story arc. They, found it, fund it, grow it big, have great success, sell it or go IPO. And that's really most of what the talk is going to be oriented toward. If you are in a business that's kind of more of a mom and pop, or it's a services company that doesn't see that arc but just wants to continue to succeed, the talk is relevant to you as well. Some of the conclusions on some of the stuff I flag will be a little bit different. Okay, so all right, so let's create a hypothetical, and the hypothetical is that you have created the latest AR, VR, MR startup. It's a virtual reality tasting device, and the company is going to be called Virtual Tongue. And God, I really hope that there isn't anybody in the room who's doing that right now, and I just stepped on somebody's toes. Right, exactly. Sorry, I was in a fly on a wall in a room. So, all right, so you've got that idea, and you know it's going to be huge. So what do you need to do, aside from obviously all of the technical work that you've got to do? What you have to do is you've got to create a vehicle that is going to be the vehicle for your massive success, and you've got to make sure the value you're creating is riding in that vehicle. Okay, and you don't want to screw that up. The foundations, when you start a company, how you found it, how you create the documentation and the structure is pretty crucial to what happens next. So we're talking about the vehicle. The vehicle is going to be a corporate entity. The value of a company like this, there's really two basic types of value. There's intellectual property and there's the great employees that you bring on. And that covers a massive part of it. So what we're going to do is we're going to talk a bit about corporate formation, what kind of decisions you need to make there, and then we're going to talk a bit about intellectual property and bringing people on and getting them settled into the company in a proper way. So the first thing is, all right, so we're talking about forming a corporation. You have enough things to do with your time. Why do you need to bother with this? And the reasons are you need protection. When you form a corporation, you get shielded from personal liability. You need the best tax treatment for what you're doing, and a corporate vehicle will do that for you. You need to be able to take an investment. You don't have an entity, you're not going to be receiving checks. And you need to hire and reward talent, and a corporation is a vehicle for that. So that's why you think about a corporation at the very beginning. Now, so the next question is, what kind of an entity? Sorry while I mess with this thing. So what kind of an entity should you be forming? And there are a number of different types. And so, the question then obviously comes up, why do I care what kind of entity it is? And the reason is those things I was talking about just above, they work in some kinds of entities and they don't in others. For example, if you are a partnership or a sole proprietorship, which is just when you own it, or an unincorporated association, which is when people are working together and they haven't done any paperwork, that's really what that is. you don't have any protection from liability. So the company or the venture does something bad, you're personally liable. You want to make sure that never, ever happens to you. So you form a corporate entity, and you don't make it one of those. So the real options that you will have will be a C corporation, an S corporation, and an LLC. And we're going to talk about which is the best. And spoiler alert, it's the C corporation. I'm going with the lead there. But I'm going to talk for a minute about why that is. So first of all, a C corporation it's your regular corporation. The downside to a C that people see the most often is this thing that they call the dreaded double taxation. And dreaded is actually part of the term, it seems like. And what happens there is the corporation makes a profit, it distributes money to its participants, and the corporation pays tax, and then the people pay tax. So you want to avoid that, and that is the downside of a C corporation. But when you are on that big Silicon Valley story arc, you manage that downside because everything else about the C is where you want it. First of all, investors prefer it, and you want to make those guys happy. It does have the limited liability for shareholders. You can have two classes of stock, and if you've heard of common and preferred, preferred is what investors like. In some of these other types of entities, you can't even do that. So anybody can invest in a C, which is not true in some of the other types of entities. There is a simple, understandable process for creating equity participation for contributors, and that's how you incentivize the people you want to keep. So you really got to make that work. So that's a C, and that really is the form. Just to go quickly over the other two, which is the S and the LLC, both of them have this magical thing called pass-through accounting, which is where if the company makes $100 and you are a 50% shareholder in the company, you've made $50 and that's what you pay taxes on. The company doesn't pay taxes by itself. It's a very simple thing, and it can be really advantageous if you're a mom and pop, or you're kind of a services company. You don't ever expect to be taking in investment. But that advantage doesn't hold up for the rest of it, because an S corporation cannot take in investment from a corporate entity, which means no investment fund can invest in you. It can't take in money from foreign investors. There aren't two classes of stock in an S. So all of those advantages, all of those flexibilities that help you get where you're going are really not available in an S. Again, if you are just going to do, if you're opening it, you're running it for yourself for the rest of your life, that may be a good option, but otherwise it's not what you want to do. LLC has the pass-through, the advantage of the pass-through. It also has an advantage of having less corporate formalities, which means you're filing less papers, but investors don't like it. And one of the reasons they don't like it is some investment funds cannot invest in LLCs. There's tax reasons for that. And also, when things happen inside of an LLC, there can be tax liabilities for the investors, and nobody likes that. So you largely aren't going to get anywhere. If you find an investor and you're running an LLC and they really like you, they're going to be like, okay, convert to a C, and then we'll talk. So it's best to start that way if that's your plan. Okay, so that's basically the form. So now you know that Virtual Tongue is going to be a C corporation. Where are you going to form it? And you can file the formation papers pretty much anywhere, in any state you want. Typically, for California companies, it comes down to 3 different states. There's Nevada, Delaware, and California. Nevada people think it has a lot of advantages because you can keep some of your information private. In Nevada, there's less filing requirements, and that can be good if you're trying to be secretive. And Nevada has a better tax structure, and here's the key thing. When you are running a company in California and your bank accounts are here or your operations are here, money you make is going to get taxed by California no matter where you form your entity. So the whole idea of forming a Nevada corporation so that you can take advantage of their tax laws, the moment that money crosses the borders and lands in your bank account in Los Angeles, you're paying taxes on it here anyway. So Nevada ends up not being a very good form unless you really are going to move to Las Vegas and run your company out of there. So you're down to California and Delaware. California is commonly used, and We have fairly sophisticated, corporate laws here, although they do tend to slightly less pro-corporate than in other jurisdictions. And again, you're going to have your taxes here, but that's, again, if you're here, that's going to be true regardless. The preferred form is Delaware. And the reason for that, I don't know the kind of the level of what you guys have paid attention to in this world or not. Delaware makes its living off of corporations. Something like 64% of all the major US corporations are headquartered in Delaware. And the reason for that is they make it really easy for corporations to operate there. They have a court system that is really designed to deal with issues efficiently. They've got knowledgeable judges for that reason, and the case law is pretty evolved too. So you really, all the good things for a corporation kind of happen in Delaware. And not trivially, the vast majority of companies that go IPO are Delaware C corporations. Investors like that form again, and you end up kind of, you don't have to start with the form that the investors are going to like, but you're certainly going to end up there anyway, and changing in the middle leads to all sorts of great horror stories, which I'll be happy to regale you with later on. So that's basically corporations. We've talked about, so Virtual Tongue is now a Delaware C corporation, and what happens next? So the next thing is you and your friends have come up with some ideas, some concepts, some treatments, whatever, and how are you going to make sure that the corporation you've created has that value? And it's not just about doing the work. You obviously have to do that, but you've got to get those pieces of intellectual property inside the corporation. So we're going to talk about IP for a minute, and that's not Internet Protocol, that's intellectual property, and that's. And so what I'm going to do first is I'm going to give you kind of a basic overview of the areas of IP that we're talking about, not so that you can become an expert, but really so that as you're working, you can go, oh, hey, this is a thing, this thing that we're doing here is capable of this kind of protection, and we should really get on that, talk to somebody and get that done. So I'm going to start, and I'm going to talk about copyrights for a couple minutes. And this is where I read because it's just more accurate than me winging it. So copyright is a form of protection afforded to authors of original works of authorship fixed in a tangible medium of expression. So that can be literary, it can be dramatic, it can be musical, artistic, and certain other intellectual works, and it can include code. So let's unpack this for a second. First of all, original works of authorship is self-evident. It has to be original. So fixed in a tangible medium, the purpose of that is that an idea cannot be copyrighted. So rather, it's the expression of the idea. And the example I like to give is star-crossed lovers from two warring factions meet tragedy is not a protectable idea, but Romeo and Juliet and West Side Story are protectable expressions of that idea. So copyright is essentially a monopoly on a bundle of rights that's set forth in the US codes. The bundle includes the rights to reproduce, display, distribute, and make derivative works on the underlying creation. So if you don't know what a derivative work is, basically that's a work that is created out of or off of an underlying property. For example, Stan Lee created the Avengers as comic book characters. All of the Avengers television shows and movies are derivative works that come from the underlying. If you don't have the right to make an Avengers, if you don't have the right to make Agents of S.H.I.E.L.D., you can't make it. You got to get that licensed by the copyright holder. Okay, so that's basically what a copyright is. Now, the next question is always, well, who owns it? How do you know who owns a copyright? So generally, absent a writing to the contrary, or a specific relationship between the parties, the copyright is owned by the person who creates the work. So what I'm saying there is you either need a relationship like an employer-employee relationship, or you need some sort of written document if you're hiring a consultant to own the copyright in the work, or the person who's created it by default owns it. And this can be terrifying if you're one of those people who's created a company and you've hired somebody to, for example, do your logo. and you don't have a piece of paper in writing with them. You can tell them what you want the logo to be. You can agree on a price. They can do a beautiful one and deliver it to you just the way you like it. You pay them. Everybody's happy. You don't own the logo. So you really need to, so this is one of those like get it in writing moments. This is true for software code. This is true for anything that's capable of copyright protection. You've got to have it in writing in order to make that happen. So I mentioned work made for hire. This is outside of California, this is a really simple concept. Outside of California, work made for hire is simply the best way that a company can own IP. You own it as if you always owned it, and it was never owned by the person who created it. That's how it works with employer-employee relationships. And that's really the best way, because even a grant of all rights has weaknesses that a work made for hire doesn't. However, because we're in California, where we like to do things differently, there is a statute in California that basically says if you're doing a work for hire agreement with a consultant, and it's a single consultant, and it says work for hire in the document, they're going to get treated like an employee. That means, congratulations, you now have to give them health care, you've got to give them vacations, they've got overtime and all that kind of stuff. It's as if you just hired them as an employee, and that is one of the reasons you hire a consultant, so you don't have to deal with that kind of stuff. So you have to be really, really careful inside California with work for hire agreements. You can use them when you're hiring like a shop. You know, if you've got just a VR shop, you can absolutely do that. But in California and nowhere else, if you're bringing in an individual consultant, you're going to want to phrase that differently. So this is another one of those, talk to the lawyer moments. So a work for hire basically can get made one of two ways, and I think I just said. It's a specially ordered commissioned use for a consultant, and it's through an employment agreement. So I've already flagged the danger there. By the way, another way that California, really the West, is different is in most of the country, if you want to hire somebody on a work for hire and they get started before the document is signed, no problem, you can have it retroactively done. You don't want to do that because if they decide not to sign it, you have a problem. But you can fix it afterward if everybody cooperates. In the Ninth Circuit, which is California and the West, if people have not signed the agreement before the work gets started, it cannot be a work for hire, and there is nothing you can do to fix that. At some point, maybe the Supreme Court will take this up and conform everything, but at the moment they got more important things to do, so that is how it is. So be really careful. So the message of this part of the presentation is get it in writing before people come on and start working. All right, so there are also limitations to the monopoly grant in a copyright. The only one I'm going to talk about right now is the public domain. And public domain usually happens in one of two ways. Either somebody affirmatively commits a piece of intellectual property to the public domain, which almost never happens except in the open source world, or the term of the duration of the copyright expires. If you ever are looking for a way to help you go to sleep, you should check out the University of Cornell website for the grid on the terms of different copyrights at different times. It is long and tiny letters, and there's a million different things. So I'm not even going to try to do that. I'm going to do two parts of it very quickly. Anything that is created on or after January 1 of 78, if it is an individually created work, it's life of the author plus 70 years. If it is a work for hire, it's 120 years from creation or 95 years from publication, whichever is shorter. And anything before 1923 is in the public domain, period. Between 23 and 78, it's a hot mess, and you've really got to kind of go look it up. So, first of all, the general observation is that the law always lags technology. The fact that 3D scanning is not a copyrightable thing today does not mean that it will not be in the future, and I imagine it will be like photography is, but it's going to take people suing people and going to court and developing case law in order for that to happen, because that will certainly happen before Congress gets around to figuring it out themselves. Okay, so I'm going to jump to trademark as soon as my phone stops messing with me here. This is good. I actually can see smaller type than I thought I could, so this is actually excellent. All right, so what is a trademark? So a trademark is any word, name, symbol, or device, or any combination thereof, or that is used by a person or a company to identify and distinguish its goods from those sold by others. So there's trademark and there's service mark. Trademark is for products, service mark is for services. They're really the same. So, but just to kind of unpack that, what we're really saying is this. It's a symbol that connects a company to a product. So you see the swoosh, you know it's Nike. You see the mouse, you know it's Disney. You see the golden arches, you know it's McDonald's. That's what a trademark is. That's what it does. So, and it really isn't any more complicated than that. Now, people often wonder, like, what does it take to infringe on a trademark? And I think a lot of people have these kind of formalistic misconceptions. If I spell Dell with 3 L's, I'm good, right? Well, that is not how it is. So the standard is a very simple standard. It's likelihood of confusion. If I look at what you've created and I reasonably think that it's a Rolex watch, or it is, or it's Coca-Cola, because that's what the thing looks like, then you're going to be liable for trademark infringement. It is just that simple. So it is not the kind of thing you mess around with. Oh, by the way, in copyrights, one of the things about copyrights is the applications are very simple. They're inexpensive, and they don't take much time. And in fact, in my practice, I typically try to weasel out of doing them and have my clients do them because it's just way cheaper for them. I can't really go much faster than they can on that, and then they end up paying my hourly rate on something that they didn't really need to. Now, that is not true on trademarks. Trademarks are a more complicated thing, and they take longer, and there's more nuance to the application. So you really want to, as you're kind of going through and figuring out what your values are, what you have, you really want to get involved in getting a trademark lawyer in there, getting somebody to help you do that. And by the way, trademarks can be for the name of the company, it can be for a product line, it can be for a service. So Apple is a trademark, iPad is a trademark, Safari is a trademark, all inside of there. Powered by Intel, you see that all the time. Those are trademarks. So the trademark is really about protecting your brand, and obviously brand is huge in being successful. So you really want to, as you're going through and you're figuring out, oh, I like the name Virtual Tongue, I better get that, I don't want anybody else stealing that. You want to grab that early on so that you don't find yourself behind the 8 ball. And there are a lot of good reasons to get that done quickly. Some of them are that it establishes priority. Now, if you're the first person in the market with something, that gives you some rights, but it's not a lot. If you find yourself in a cyber squatting dispute and you don't have a registered trademark, you're not going to prevail, even if you've had it for the whole time. And you can also have extra damages that come from having a trademark, from having registered the trademark early on. By the way, that's true for copyrights as well. A copyright, you don't have to register a copyright anymore. You used to have to, but the copyright is created at the moment of creation, and it exists. But if you don't file the copyright application, then if you try to sue somebody for infringing on you, if somebody comes out with your thing and you file a lawsuit, if you don't attach the copy of the copyright registration, that lawsuit gets kicked and you will not have your day in court. So it's true that you don't really have to own the copyright, but if you want to do anything to protect it, you do. So I always recommend that you do that. It's just too simple not to. All right, so sorry about the jumping around a little bit. I realized I'd skipped that area in copyrights as I got to it in trademarks. So patents, what I'm going to do next. Now, I'm not a patent attorney, so I'm going to keep this brief. I know more about patents than most people and a whole lot less than the people who practice in that area. So I'm just going to give you like the general proposition, and obviously patents are critically important to certain companies, a lot of them. So patent law protects a new and useful process, machine, or composition of matter, or any improvements thereof. It's got to be new, useful, and non-obvious. And it lasts for 20 years from the date of the application, and assuming that it gets issued. And it basically gives the patent holder a monopoly on the manufacture of a certain type of product. It's not so much that you have the right now to make it, but you have the right to prevent other people from doing it. So the other thing about patents is that, that the law in the US just changed in the last few years. We used to be a right to invent jurisdiction. Now we are a right to file jurisdiction, which means that you had better get there fast. Once you create it, you got to get in, and there's all sorts of potential problems with publicizing what you do before you get to the patent office. And so you see a lot of companies, you will not see anything from them in the way of patents until, you won't even know what they do until the patents are filed. So this is a very important thing. And that change, just to kind of opine for a second, really did not do any favors to the small businesses, because obviously the big businesses that have patent firms on retainer can crank that stuff out in a way that the less well-funded companies can. So patents are much more complicated to do. They take longer. They take several years. And you're not going to get away for less than $3,000, and it's usually a whole lot more than that, $10,000 to $30,000, depending on the complexity. So there's often a conversation happening inside of startups. Is it worth doing? And sometimes yes, and sometimes no. But you really want to involve a patent attorney in that conversation as early as you realize that you got something there. Now, okay, so that's patents. Related to patents is trade secrets. And a trade secret so the World Intellectual Property Organization defines trade secrets as follows: any confidential business information which provides an enterprise a competitive edge. That could be sales methods, distribution methods, consumer profiles, advertising strategies, lists of suppliers, clients, manufacturing processes. It could be anything. Often it's anything that a patent can be and more. It could be a new type of software, a unique algorithm that you've developed to facilitate doing a creative work. That often happens. So the interesting thing about trade secrets is that they offer something that patents don't, and that is, and sorry about the P's, potentially perpetual protection. So if you can keep a trade secret a secret, it never has to expire. Now the trick is that when you try to figure out what is a trade secret and what isn't, there are complicated rules and the laws are different in different places. They usually boil down to two things though. One, how important is the secret to your company? Two, how hard have you been trying to keep it a secret? So that's really the standard there, which is one of the reasons, by the way, that you use non-disclosure agreements way more than anybody of your friends thinks you ought to. Once you give up a piece of a secret to somebody without some kind of restriction, whether it's an NDA or an employment agreement or something like that, if you give it to somebody else under an NDA and they reveal it and you want to sue them for trade secret violations, they come back and they go, well, hey, they gave it to this guy for free, and that blows up the trade secret exemption, and they're right. So you do not ever want to be cavalier about that. You have secrets. We all want to be like, let's give everything out there, but you've really got to protect what you have. So the interesting example in the trade secret world is the Coca-Cola syrup formula. So Coca-Cola's been around for about 130 years, and I think it was about 1900 or so that they arrived on their on the version of the formula that was lacking in cocaine, and that's the one that they've been using pretty much ever since. Now, had they patented that, they would have had to have disclosed in the patent documents what the formula was, and they would have had protection for, I think the term around the turn of the last century was 17 years. And by 1920 or so, that'd be in the public domain and everybody would be drinking their version of Coca-Cola however they liked. But they didn't do that. They kept it a secret. It's locked in a vault. Probably less people know that than the nuclear codes, and that is still a trade secret. And there's all sorts of people out there who speculate on what it is, but nobody other than a couple of people really actually know what that trade secret is. So, but the problem is, of course, the moment that trade secret is blown, it's blown forever, and there's nothing you can do about that. So trade secrets should be part of what you think about, but it's not going to be something you're going to commonly use like in lieu of a patent application. All right. So let's see. Yeah, I'm going to spend about 2 seconds, that's not really true, on rights of publicity. Rights of publicity is basically protection of the image and likeness and voice and all of that of people who are famous, people whose image actually has value. So if you have a photo of Steven Spielberg using the virtual tongue, and you're like, oh, this is going to be awesome for our advertising campaign, well, you better check with Steven first. And you're going to have to get a release from him, and that's probably going to cost you. And if you go out there and you use it without his permission, that will be an unhappy day for you. So that's something, just be aware that you can't just go, oh yeah, I want to grab that because that'll go great with what we're trying to talk about. Okay, so that's basically an overview of what IP is, and what kinds of IP we're really talking about here. Now you want to make sure that it gets inside of your company, because, and I have seen this, where somebody creates an idea and they don't put it inside the company. And I've actually seen people invest in companies where they didn't bother to check and see whether the concept was actually resident inside the company, and that's just a terrifying moment as a lawyer. But sophisticated investors will never do that. If they will come in and they will look at your documentation, and if they see what your main value is and they can't find the trail of how it got into the company, you will not get a check from those people. It's just not going to happen. So you want to make sure that the IP gets in. And the first thing you do is you take your original IP and you do license agreements or whatever. You contribute it. Maybe you contribute it in exchange for stock in the company. But that's kind of the first move, is to get that IP in there. The next thing is that you deal with your startup team. And your startup team is, everybody signs non-disclosure agreements. Everybody who comes in signs an employment agreement, if they're employees, a consulting agreement if they're consultants, an advisory board member agreement if they're advisory board members, and I'll talk about each of those and why you would have them in a minute. But bottom line is all of those agreements will have an intellectual property section. In Silicon Valley, they really like to use something they call a PIIA, which is a Proprietary Information and Inventions Agreement, and it's going to cover copyrights, trademarks, patents, confidentiality agreement, all that kind of stuff. Non-competition, to the extent that it is available in California, and in some very important ways it's not, but that's another conversation for another time. But so you'll have that PIIA is going to be critically important, and believe me, I have been through situations where investors are coming in and they're looking through hundreds of employment agreements to see if the PIIAs are all written properly before they drop in large sums of money. So you really want to make sure that that system is in place. So the basic idea is, as you form your entity, you get these, you work with a lawyer, you get these forms. You don't have to have them create all of them, but you do need to have the right form to go for, and you don't ever forget to use it. So all right, so what else? Advisory board member, yeah, process. Okay, so the other thing is, you ultimately want to create like a funnel inside the company where your IP, where people who are creating your intellectual property, doing the inventing for the company or the innovating, are aware of this idea that you need to protect that and you need to get your filings done. So there should be communication between the creatives and the business people, and if you've done your job right, there's a funnel. So basically every time something pops up, somebody who's in a position to help you protect it knows about it, and they can go ahead and do their work. And that is not as easy as it sounds, but it's a very important thing to do. All right, so we've talked about kind of the foundational documents there. Then you're going to hire people. All right, and this kind of skips to the idea. It kind of dovetails with the idea that the most valuable things inside your company are the intellectual property of the people who are creating it and the people who are creating it. So if you want to create a really successful company, you've got to have great people inside of it, and there's just no two ways about that. So you want to bring on the right people. I am not going to, it's definitely beyond the scope of this talk to say, how do you identify who's good and who isn't, what is your corporate culture and all of that. Very, very important issues, but not part of what I'm going to talk about here. What I want to say here is that when you're hiring people, you're basically going to bring on employees, possibly consultants, advisory board members. Those are kind of the categories of people that you'll be wanting to have inside your company. And so how do you decide which is which? I mean, it's basically when you hire an employee, it's because you want them full-time, you want them to be fully focused on what you're doing, you want them to be exclusive to your company. You've identified somebody who's going to create some great stuff for you, you want to work with them, you bring them in. And when you do that, then you take on the potential liabilities of an employee, but the idea is you just factor that into your costs, and it becomes worth it if the person is incredibly valuable to you. You use consultants when there's somebody who has a particular skill set that you need a bit of, but you don't need it all the time, or he's awesome and you just can't get him to come in full-time or exclusive. She's got too many other projects going on that, and she's not going to do that, but you still need her skill set. So in that situation, you bring in a consultant. And an advisory board member, having an advisory board is a really good idea. And what you get out of an advisory board is, first of all, the advisory board members are people who, they're not going to work for you. They're probably pretty high level. They know stuff that you don't know yet. They know people you don't know yet. They're, maybe they are, it's somebody who's, one of the top people in the field of machine vision. Or you've got a consumer electronics product and you need somebody who understands the manufacturing area. Well, you don't need them on full-time right away, but you need them to say to you, hey, you're thinking about this wrong, or you're thinking about this right, or I know some people you should really talk to, or I work with Stanford and I can get you a funnel to some incredible grads who will come to your company. These are the kinds of things that advisory board members are really good for. So you pick their brain once a month, you give them a little bit of equity for that, everybody's happy. And that's a really good thing. And by the way, investors like to see that as well. If you are connected to some really powerful people, that really helps you get your finances in. That will help convince people of that. So each of those people has an agreement. The employment agreement we talked about briefly, and the main deal points are really, what is your title? What do you actually do? How long are you doing it for? Is it for a specific term or is it at will? California is what we call an at-will state, which means that unless it says otherwise, you can terminate anybody at any time for any reason other than the really bad, civil rights reasons you can't. That's always better for a corporation because it maintains your flexibility. If somebody's not working out, you don't want to sit there and look and go, oh, they're on the payroll for another 18 months. I wish I hadn't done that. So that's, and then obviously the compensation, which I'm going to talk about in a second, and that's, the cash or the equity. Consultants also will have that agreement, and those are less complicated. What are you doing for us? How long are you doing it for? How much are we paying you? When is it due? And then all of that IP stuff. And advisory board member agreements are usually less complicated than that, but they all have to have that IP provision in them. So all right, let me talk for a second about equity. And I'm going to do this super basic. Probably a lot of you already know this stuff. There's stock and there's options, okay? Stock is basically a percentage interest in the company, and that's what it is. Options are a piece of paper that says you have the right to buy stock in the company at this price that we are establishing today, no matter how much the price of the stock goes up in the future. So as a company does what it's supposed to do and gains more value and the stock becomes more valuable, the option grant can become a very, very valuable thing indeed. And very quickly, when there's two different types of options. There are incentive stock options and there's non-qualified stock options. Incentive stock options give you better tax treatment. It's what most people want, but it's really only open to employees. The tax codes make that clear. The consultants and advisory board members and the rest of the world, other than certain types of investors, but if you're getting it as compensation, you're going to get it as a non-qualified stock option, and you're just going to have to deal with the tax consequences of that. There's kind of no real good way around that. Let's see. So that's kind of it. I know I'm flying through this because I wanted to leave time for questions. So the bottom line is that that aside from everything else about getting all this stuff done, and I know I've already mentioned this, investors are much more likely to invest in you if you have done this right for a couple of reasons. One, you make it a whole lot easier for them to understand what it is you're doing and that it's really all put together. And two, investors really gravitate to companies that are well managed. And it's the old real estate thing. The three most important things in real estate are location, location, location. The three most important things in investors' minds are management, management, and management. And if you come to them and you're buttoned up, they are going to like that a lot. And if you are not, it's going to concern them. So you really want to, you want to take care of this stuff. It is the unsexy part of what you do, but it's the part that really enables you to keep doing what you do. So, seeing your invention or your idea come to life is an incredibly exciting and rewarding experience. You may know what needs to happen from a technical perspective, but if you don't take care of these legal and business issues, you may never achieve your dreams. If you pay attention to the issues that I flagged here, you're on your way. Of course, it only gets more complicated from there, and so make sure that you assemble a really good business team to navigate the minefields. And that's what I got, so if anybody has any questions, I am happy to take them. Thank you very much. Okay, is Danielle here? Or, oh, you've got the, somebody's got the mic. All right, that gentleman.
Testing, okay. All right, this is coming more from a service-based company perspective.
Okay.
But there have been a few contracts that have passed my table where some language has come up where it talks about the client being able to have paperwork signed on your behalf as if you yourself signed it.
Right, power of attorney.
Yeah, the language isn't quite so nice in how it's put, but yeah basically that. And I've always fought it because I believe that, any paperwork that gets signed, I should be able to read and everything like that.
Yeah.
And I get around it by saying things like, well, only after you exhaust every method of communication or something.
Right.
But I'm curious to get a lawyer's perspective on why that language is there. Is it something that we should be very careful about as a business owner? And, that general
Well, so if
area.
you're the business owner, you might find that language in some of the documents that you put out. I mean, for example, if you've got somebody who has created some IP for you, and you may at some point need them to sign off on something, to sign off on a grant or something like that, and you don't want to be in a situation where you keep handing them the piece of paper, which was clearly part of the bargain, and they're not signing it. So oftentimes you'll have something that will say, you agree to sign this, and if you don't sign this within, 3 days of it being proffered to you, we get to sign it for you. Something like that. So there's a very good reason for that there. Otherwise, it kind of depends. It really depends on what kinds of things they want to get you to agree to kind of waive your right to look at.
It was more to do with rights to the IP itself, a work-for-hire style agreement,
Right.
Where they're saying that, if there's additional paperwork required that
Exactly.
is going to further their ownership of the work, then they want to preserve the right.
Yeah,
to be
that's
able to sign
exactly what
that.
I'm talking about. And
Okay.
and that's from a company ownership perspective, that's pretty important because you can't
Okay.
have somebody who has created something for you and you've all agreed that it's going to be. You can't have them hold it up just because they don't get around to signing something.
Okay, so just to verify, that is common language.
It is common.
Okay.
Yeah.
All right. Thank you.
Sure. Let's come up this direction.
I totally agree with you that the investors, it's imperative that you have a good management, but that you're protected in all aspects, from corporation to trademarks to IPOs.
Right.
I have a question regarding a patent versus trademark, trade secrets versus PIIA.
Okay.
Okay. We've done a lot of patents, and it's tedious, and it takes a long time, and there's no guarantee.
Yeah, and it costs a lot of money too.
It costs a lot of money.
Yeah.
The trade secrets there's no guarantee, but is it less consuming and less time and less expensive?
Yeah, because you don't have to do anything other than keep stuff a secret. There is no filing for trade secrets. You just don't tell anybody, or you make sure that anybody you tell is under some sort of a confidentiality provision.
Right. So
It's definitely cheaper and it's easier, but if somebody makes a mistake, you're toast.
So obviously you get a trademark attorney to help you.
Yeah. And the thing with patents also, not only is it expensive, but when you have that right and you're a small company and Microsoft decides they're just going to infringe, you find yourself in a multi-million-dollar patent lawsuit. And so the question always comes up, is it even worth it to try to protect this thing if enforcing your rights is going to be impossible? So it's a question you have to ask.
Yeah, that's great. And my last question was the PIIA, which is a Patent Intellectual Investor Agreement. Does that protect you as much as the trade secret? Or is that like a package of everything?
So a PIIA is, if you're the company, you're going to hand that to everybody who works for you.
Correct.
And it's going to have provisions on copyright trade. It's going to have provisions on everything we talked about.
Correct.
And so that's essential if you're running a company and you're bringing people in.
And even if they're contractors, correct?
Yeah, that's correct.
Okay,
that's correct.
thank you.
I mean, sometimes the form of that looks different than if they're a contractor or if they're an employee. The attachment may look different, but it will have all those basic terms in
And
it.
even though they signed an NDA and a non-circumvent, they still should do the PIIA.
Well, and oftentimes, and I didn't get into this too heavily, but oftentimes an NDA basically says, the purpose of the NDA is, hey, we're going to talk about something. I'm going to tell you something about how I do what I do so that you can decide whether you want to get into business with me or not. And it's that so you can decide whether you want to get into business with me or not that can be dangerous, because that's exactly what it should be. But at the same time, that means that once you enter into a deal, once you've decided, okay, I've seen what you got and I do want to get into business with you, then that NDA may not apply any longer. So you move from the NDA to one of these other kinds of documents that has its own confidentiality language in it.
I agree, but also does a non-circumvent with an NDA combined, would that be able to protect you?
Yeah,
Okay.
I didn't get too deep into that, but yeah, that's correct.
Yes, hello.
This gentleman here?
Sorry, I got
Somebody over there.
right here. When you, is there a way of protecting yourself from when you take on additional funding from having your equity being reduced? Or is it, that's just part of the gamble?
Yeah, okay. That's part of the gamble. I mean, you know, if somebody comes in and they invest in the company, they want a piece of the company. They are taking that gamble with you, and they're going to take that out of the already existing equity. I mean, they may not necessarily take it out of the existing. I mean, like technically, you issue new stock, but your percentage of the company goes down. That's just how it is. And this is a whole different conversation, but it is not unusual for the founders who started out with 100% to wind up with 30-40% at the end of 2 rounds. That's just what happens. You know, so, oh, by the way, something that, because this thing is so small, I skipped over it. Founders shares, when we talk about equity, there's a touchy issue with founder shares. So there's 3 of you, they created Virtual Tongue. You're a third, and that's all good and everybody loves each other. And then it's 6 months later and it's going slowly, and one of the guys gets an offer he can't refuse from Apple, and he's gone. And guess what? He still has a third of the company. And you know, you may love him, but that doesn't seem fair anymore. So there are vehicles for making sure that that doesn't happen. There's something called restricted stock, in which your stock, the company has a right to buy back your shares, and the longer you're there, the less of them they get to buy back. And then options also work in kind of the opposite, but the same way, which is you vest over time. So sometimes what you do with the founders is everybody gets X number of shares and a bunch of options, and if everybody stays over 4 years, then they're all equal, and anybody who leaves early stops vesting. So that's just something that you're going to have to flag. All right, sir.
On NDAs.
Yes.
2 questions. One, for the Virtual Tongue, you're talking.
It's a good name, isn't it?
Oh, it's.
I was very proud of myself at 3 in the morning when I thought of that one.
You're speaking with a dentist who you want to potentially work with.
Right.
And so you sign an NDA.
Yeah.
Then you end up deciding it's not going to work out.
Right.
what if, as part of what you've revealed to the dentist about the virtual tongue is a dentistry educational tool that has to do with the tongue?
Yeah.
The dentist then decides he's going to create a dental educational tool, but it has nothing to do with a virtual reality or virtual tongue.
Yeah.
Is that even gray, or?
It's a little gray, but not very. I mean, if what you want to do, like when you do the NDA right, not only do you have them sign the NDA, but then after the meeting, you send them a letter and or an email, and you say, hey, thanks for the meeting. It was really great talking to you. I really enjoyed speaking to you about this, 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 and this. And if that educational tool is on there, then you know it's under the non-disclosure agreement. It doesn't really have to be your core business. It just has to be something that's been identified. And NDAs have an infinite variety of how you flag that kind of stuff. But that's, you know, but yeah, you definitely, you can enforce it.
And so even if it's an idea and it's never been done by either person, like the person who reveals it, it's still an idea. Now that's a way to protect it.
Yeah, if they've signed a contract saying they will not do anything, and the NDA will always say, I'm receiving this information for purposes of evaluation only. This doesn't transfer any rights to me to do anything else with it other than use it to evaluate whether I want to work with you. So yeah, that
Then
will.
Part B would be if it's a 3-year agreement.
Yeah.
3 years and a day, anybody can do anything.
That's true.
Okay.
But what you want to do with that is you have a 3-year term. There's actually two. Sorry, am I running along here?
Yeah, this is your last one.
Okay, so just to kind of go a little deeper in NDAs for a second, there are 2 end dates in an NDA. There's the date that the contract is over, and that means if I have an NDA with you through August of 2019, and that means that in July of 2019, I can tell you stuff and it's still governed by the terms of the NDA. And after August of 2019, it isn't anymore. But there's a second date in the NDA, which is how long after the term do you have to keep it a secret? And so the dangerous NDAs are the ones where both of those dates are the same date, because then it's August 3, 2019. I've told you a secret. The termination is on August 4, and it's all yours on August 5. What you want to do is, 3 years after the end of the term, or 3 years after I told you the secret, or something like that for that second date. Okay, I'm done. Thank you, everybody.